The deposits, there are two kinds of deposits in Texas. One is called an application deposit. Typically, you go in, you fill out an application. They want you to pay an application fee. They want you to pay an application deposit. And the law says that if your application is rejected, you are entitled to get that deposit back. And so if you are approved, then that application deposit converts to a security deposit. And the security deposit, again, is something that is refundable to you after you fulfill the terms of that contract. Most tenants know the lease begins and ends on a certain date. Most tenants know that they have to give that required 30 or 60-day written notice of their intent to move out. And unfortunately, some tenants don't know that they also have to give a written statement of a forwarding address in order to get that deposit back. So you want to close up those loopholes. Do give proper written notice of your intent to move out. Do include a written statement of a forwarding address. It doesn't have to necessarily be your forwarding address. It has to be a forwarding address. That could be a post office box. It could be a friend or relative's address. Just close up that loophole and provide them with a written statement of their forwarding address because otherwise they don't have to return your deposit. They don't have to send you an itemized list of deductions. I believe that most tenants do leave those rentals neat, clean, empty, without any damages, but you want to have proof, and that is after you've moved all of your possessions out, you go back in with your cleaning supplies. You're going to sweep, dust, mop, vacuum, clean the surfaces. Then you want to start taking photographs. You don't want to just know that you left that place in neat, clean condition. You want to have proof, and a visual record is a good way to do that. So open up the cabinets, open up the closets, open up pantries. Anything that's closed up, open it up and take a picture so that you can show the inside of it is not only empty but clean. That includes refrigerators, microwaves, stoves. Open up that oven so that you can show if people are making claims that you didn't leave the place clean, then you want to have a visual record to show that you did. The other thing is when you first move in, that inventory condition form, that is not a request for repairs. And so a lot of tenants will not list anything that's in less than perfect condition. If there's a little ding here or a gouge there, that may not be a big deal to them, so they won't put it on the inventory condition form. They will only put the big glaring things that they want addressed, and that's a mistake because the inventory condition form is for you to note everything that's not in pristine, perfect condition. Even if you don't care that they don't repair it, you still don't want to be charged for that after you move out. And so the people who process you in may not know what it looked like. The people who are processing you out may charge you for those little dings and stings and gouges that you didn't put on your inventory sheet. So go through that place with a fine-tooth comb and list everything that's not, as I say, in pristine, perfect condition. Keep a copy for your own records. Don't turn the only copy in. So before you turn it in, go somewhere to make a copy for your own records so that you can have a visual piece of paper that shows those conditions. The law says landlords cannot charge tenants for normal wear and tear. Normal wear and tear is defined as deterioration from normal usage. So the law recognizes that even if you're careful and you're using a thing for the purposes intended, it's still going to get old, it's going to get worn out, it will need to be replaced or repaired through no fault of yours. Relatives around on the last day of your move out so that you'll not only have your photographs, but you'll have people who can verify that you left that place in neat, clean condition. And that's typically the people that we get to help us clean the place, to move, our family, our friends, that kind of a thing. So have somebody around that can verify if you need to in the future to verify that you did leave the place in acceptable condition. And the law says landlords have 30 days from the date that you move out to either return your deposit or to send you an itemized list of deductions for those damages. And so Sometimes they'll keep some, sometimes they'll send some. They'll do a little bit of both. They'll keep some and they'll send you the balance of that deposit. The law says if a landlord doesn't return your deposit, doesn't send you an itemized list of deductions within 30 days of your move out, they are presumed to be acting in bad faith with you, and they forfeit the right to withhold any portion of your deposit. So you look at the calendar, you see when it's 30 days from the date that you move out, you've got, all of your obligations covered. You did give proper notice. You did give a written statement of your forwarding address. You did leave the place in neat, clean condition without any damages. You do have photographs. You do have friends and relatives around who can also verify that you left the place in neat, clean condition. And they have forfeited the right, and they can be held liable for 3 times the amount plus $100 of your deposit if they fail to send you something within 30 days. Some tenants complain that they did get something within 30 days of the move out that they don't agree with, that it's a bunch of chumped up charges, invalid charges, or pre-existing charges, are normal wear and tear charges. So if you receive something in writing within 30 days of your move out that you disagree with, you want to consider responding in writing. You don't want to call them. You don't want to go to the office and talk to them about receiving a bill. You want to respond in the same way, meaning on a piece of paper. Very simple. I'm writing in response to the bill you sent. You made a number of errors that I'd like to correct. And then item by item go through that bill, explain why you disagree, summarize at the end of your letter what your expectation is. Certainly that is to correct their errors, to send you the amount of money that you expect to get back. You want to give them a deadline in which to do so. We suggest 10 days is a good reasonable time for them to correct their errors and send you the money that you expect. Tell them otherwise you intend to pursue your own legal remedies. Thank them for their prompt attention. Sign it, keep a copy. We suggest you send that letter by certified mail, return receipt requested, or registered mail, or some other trackable form. In other words, you want to start creating court-worthy documents, not just texts or faxes or emails, and certainly not just chatting with them or verbalizing your expectation. You don't necessarily need an attorney. If you want to pursue your legal remedies, what you need is good information, good coaching, good training on how to represent yourself. We think that we do a great job in helping tenants represent themselves. We are not sue happy, however. We are not going to encourage you to go to court if after we sit down and talk to you and we see that you don't have what you need to prevail, we're going to give it to you straight. So allow us to grill your case. Not that we're trying to make you feel defensive or offended. It's just that we don't want you to leave this office with a notion that you have a strong case and then you go and lose miserably. That reflects on us too. We want to keep our good record. So allow us to review with you so that we can give you our best opinion about the strength or the weakness of your case, because sometimes pointing out where you may have dropped the ball allows you to regroup and to set a better course and to increase your chances of winning. The statute of limitation is 2 years from the 31st day of your move out, because they have that grace period, that 30 days to return your deposit. And even though the statute of limitation is 2 years, we suggest that you maintain your momentum. If something happened August 2018, you certainly don't want to wait until August 2019. You want to respond to issues in the season that it occurred.